Yeah, okay. So hi everyone, and welcome to the YouTube channel of Get Set Law by IMS, guys. I hope I'm clearly audible and visible to everyone. Okay. So I'll just share my screen and we're going to do a small tech check so that I can just see that I'm clearly audible and visible. Channel of Get Set Law by IMS. Okay, perfect. Fair enough. Okay, so a very good afternoon, everyone. As you guys have been following up with these sessions, which we have been taking for you people, the sessions for sessions for logical reasoning for English language have been taking place in the week's time, and then now we are there with the legal reasoning practice session. So the objective of the session is majorly about to get gel up with any sort of questions which might come. So we have tried to keep up limited set of questions and to understand. It's not about getting the right answer or the wrong answer, but what is the main purpose is to understand what exactly that particular type of question to be approached. Okay. So let's start with the session and over here. Yeah. So as you can see it up on the screen itself, that in this particular session, the topics which I'm going to cover. So in the previous sessions, if you have watched it, that's great. If you have not watched it, guys, go to our YouTube channel, Get Set Law by IMS, and go check it out. The video that is Decoding CLAT 2026, and we have a practice session, a proper playlist. Okay. The second thing, if you are there on our YouTube channel for the very first time, don't forget to subscribe to our channel, guys, because when you subscribe, आप subscribe करते हो, we get that motivation कि okay, chalo, people are watching, people are appreciating, and if you like the video, hit the like button. Okay, because that is where we get that motivation to come up with new videos for all of you. Okay, so the topics which we are going to cover up today is two topics, that is the Indian Ports Bill, that is in the year 2025, and a due diligence which majorly happened in the Prevention of Money Laundering Act. Okay, both are related with the current legal portion. So this is a surprising thing which might come in the paper. You must have read about it somewhere in the newspaper. If you have read it, or in the monthly magazine, you must have read about the legal articles which are again. So that is what the topics is about. So now you know the topic. Okay. Now, in this particular session, at the end, what will going to be the major takeaway is be how you will going to approach a particular new topic altogether, and certain questions which have a lengthy facts as well. So at times, CLAT put up, so the paragraphs seem to be quite unknown and the facts are also lengthy. So if this is a surprising thing. If something like this happens in CLAT 2026, what is going to be there? Okay, so this is the first paragraph on the screen. So I'm going to read it up. I'm going to explain and the approach, and then we'll see what the questions are. Five questions for two paragraphs. Let's start. Okay. And if you are not able to understand any of these things, you guys have to put up the comment. If you watch it later on, I'll just see the live chat as well so that I know who all are live right now. Perfect. Give me just a minute. To see the chat. Give me a minute. Perfect. Okay. Okay, thank you so much, guys, for joining the session. Okay, so let's start with the first paragraph. So as you can see, the length of the paragraph is somewhere the 4 paras in total, which are there, ranging around 250, 280 to 320 words, not more, not very hardcore on the reading portion, but it's a new topic. So what is going to be there? There are two things. Either you're going to get at the end of the paragraph in the brackets, the edits and the source, which is going to be there in the second paragraph. So over here, you don't have any edits, you don't have any score which is being provided, right? So the source. So how you're going to approach? You just read it. A new topic, you read it. Don't get scared. Mujhe to pata nahi. I don't know. No, don't do that. What is the approach? The first thing, read it. Okay. So let's read it. It says, yeah, hi, good afternoon, guys. Once again, chalo. So to modernize Indian maritime governance, the Indian Port Bill 2025 has introduced in the Lok Sabha seeks to replace the century-old, that is 1908 mein bill tha. It came to be almost more than 100 years it has been. Now, what does the bill say? So this is an introductory portion, read it, move ahead. The bill redefines the roles. Now, this is what is important. It redefines the role. As I've been saying, I just put up a box and underline only to the portion. When you just revisit the paragraph again, you'll understand कि okay, chalo, ठीक है. This is where I have to again read it. I don't have to read the entire paragraph. So redefine the role of the central and the state authorities in relation to the port governance, and so it's redefining and it is introducing significant regulatory architecture which aimed at promoting coordination, transparency, and sustainability across ports, especially for non-major ports. An introduction why the bill was introduced. So redefining, introduction, next paragraph. One of the bill's most transformative feature, now it is a transformative feature, is the creation of the Maritime State Council. So MSDC have been created, chaired by Union Minister of Ports. So at the center level, who's the ministry? That's bill chaired with representation from state ministers, defense representatives, and senior bureaucrats. So that is how the pool of this council is going to be there. The council will issue. Now, what does council will do? They will going to issue. Now, this is what you have to pick up. Either the feature, the objective, the advantage, the disadvantage. These are the areas which you need to just highlight into that paragraph when you come across something new. So at least मैं उतना तो जान पाऊंगा कि चलो it is redefining some roles, it is defining some transformative features, a new council, and certain guidelines. So it issue guidelines and recommendations related to what? Now it is related to something. It's related to data collection of the port. It's related to storage, tariff transparency, while advising on a national perspective plan for maritime development. So these are the ones where they issue guidelines and they issue recommendations also. Now, the plan is envisioned as a unifying blueprint to which the central government and state governments, major port authorities, state maritime boards must adhere. So there is a plan which they are actually highlighting. Okay. What is that plan? On a national perspective plan for maritime development. What is this plan? Now the plan has envisioned. It's not the council or the bill. They are talking about that the council will going to issue guidelines, recommendation related to an advisory on the national perspective plan on the maritime development, and this plan is a unifying blueprint to which central, state, and all the other authorities, state maritime boards will adhere. They will going to follow. Okay. Now, bill also grants statutory recognition. Now, it is talking about the recognition for what? To the existing state maritime boards, such as those in. I hope everyone is able to see the screen. Just a confirmation for all the live viewers. Okay. You guys liking it or not? Just let me know. Such as those in the Gujarat, Maharashtra, Tamil Nadu, and mandates that state establish SMBs within 6 months of the enactment. Bill के आने पे ही 6 months के अंदर you have to establish your own boards. Okay. So this is what they have given the recognition to it. Now these boards will handle licensing of port structure. Now, what they are going to do? They are going to do the licensing, the tariff fixing, the supervision. I don't want to get deep into it what it is because I just need to understand and go because it's there in the exam now. And navigation regulation with the state port limits. Okay. So that is what licensing, tariffing, these are the boards which are going to do. The council ka feature alag, boards ka alag, but boards have to be established within 6 months. Any dispute resolution is localized through a state appointed committee empowered to adjudicate conflicts among non-major ports and associated stakeholders with appeals line to the High Court. So High Court maybe you can go. Now appeals you can make it up to the, but the resolution has to be through a state appointed committee. But the boards state में उन्हीं committee में adjudicate conflicts. Bill also introduces comprehensive environmental obligation. That means they need to see whether they are following up with the environmental norms or not. Okay. So that is what they're talking about. Ports must submit waste management plans and report pollution threats promptly at the state and the central level. Okay. So that means they need to report any pollution threat also promptly, तुरंत जैसी पता चला, but at the state and the central level पे it has to be known. So this is an important catch. ठीक है. So bill is introducing environmental obligation as well. You need to follow those things and threat है तो बताना पड़ेगा state and national level पे. Failure to comply attract penalties. ठीक है. So if you are not complying with these provisions of the bill, either from fines to imprisonment, depending on the severity. जो जितना ज्यादा सीवियर उसके बेसिस पे either it could be fine to imprisonment. So fine से लेके imprisonment तक it could range, and depending upon the violation you have done, ranging from commencing operation without notification to disturbing geophysical structures without clearances. Okay. Importantly, offenses under the bill are graded. When it says offenses in the bill are graded, that means they have put up the higher level offense, maybe say grade 1, the lower level offense is grade 5. That is how they've graded it. Okay. Some attract only monetary penalties, other include imprisonment to 6 months. So only penalty is less, but imprisonment up to 6 greater. जितना ज्यादा होगा उतने लेवल पे लेके जाएंगे. This tiered structure underscores the legislative's attempt to strike a balance between deterrence and administrative compliances. So that the structure have been there so that are you willing to do it, or there is some non-compliances which are happening. That's why we go into range. That is what is the paragraph is all about. So the language on the easier side, not very tough, is understandable. But yes, for the first time, reading it for the very first time, no idea about it, a bit difficult. So let's go to question number 1. It says AB Maritime Private Limited began operations at a newly constructed private port in Andhra Pradesh in June 2026. So June mein aaya, okay. And it's talking about some hypothetical situation, but without an official notification by the state government. They have already begun operation, but no notification. On July 26, a vessel leaving the port did not report the presence of leftover oil waste in its containers. That means they should have reported it but have not reported leftover oil. Okay, non-compliance. Upon investigation, it was revealed that the port had not filed any pollution-related reports with the authorities since operations. So they have not even, now it clearly mentioned that report pollutions should be done, submit waste management plans in the bill. And it's June 26, they have started July, May, it has not been an investigation. Se pata chala. However, the report also highlighted that no substantial damage was caused due to the same. Now they are saying there is no substantial damage. बहुत बड़ा damage कुछ नहीं हुआ, but non-compliance. Based on the bill, which of the following is the most accurate legal consequence? So now there is some negligence being done on their end. इन्होंने follow नहीं किया, मतलब definitely कुछ तो penalties होंगी. But it will range from fine to imprisonment. Let's understand what it could be. So first answer, yeah. So Ameya, the overall paragraph is majorly about the introduction of the new bill. Earlier, the bill was already there in 1908, but it has been introduced in the year 2025. They have redefined the structure of the central and the state authorities. They've even introduced a new council that is being chaired by the union minister, and the council have issued certain guidelines, recommendations. The bill have also supported and pushed the recognition of the state boards and their responsibilities, what the boards are going to be responsible. They'll handle port, tariff fixing and all sort of things. And they've also introduced an environmental obligation also, that the ports should submit their reports. And if anything does not happen, then the penalties will going to be there and it will range from fine to imprisonment. Okay, Amir, that is what it is about. Okay. So now the question comes, which of the following is the most accurate legal consequence? So first says a maritime private limited is liable for imprisonment up to 6 months for both the lack of pollution reports and starting port operation without notification. Could be the option, okay, because it's talking about imprisonment up to 6 months. The vessel owner may be fined, but the port authorities are not punishable unless coastal waters were polluted. Now this is subject to certain conditions, which they are highlighting. If the coastal waters are polluted, then they could have been liable, but you have to submit the report and it's an obligation. Ports must submit waste management plans and reports, pollution threats promptly at state and central level. ये आपको करना ही, but you have not done it. Okay, so there is something wrong. So he may be fined, it says, but the probability is not sure. He has done wrong, so he will be fined. This is wrong. The port is liable for fine up to 1 lakh for failing to report pollution and a separate fine of 1 lakh. This is talking about a fine. And again, a port failure to file pollution report invites a penalty of 2 lakh. Now, both of the options could be considered. Maybe 1 lakh could be the correct answer. But the reason is a fine of 1 lakh, is it too much or is it too less? Penalty of 2 lakh, is it too much, too less? We don't know. Since no information related to these are given, we can't go with these options until and unless we have an answer related to a fine or an imprisonment. Okay. If 1 lakh or 2 lakh would have not been mentioned, there could have been debate between A or C or A or D. So we will go with A only. Now it won't be considered that outrightly it's the only option which is correct. No, but after the elimination, we are only left with this option. So we'll go with this thing. Okay. The correct answer, if the statement in the option could have been something better, but we created these options just to have a sense of confusion, and it can happen during exam as well. Okay, so use elimination and important learning. Okay, note it down. Note it down, everyone who all are live right now. Okay, perfect. That is, which of the following best captures the function of the Maritime State Development Council? That is MSDC, जो council बनाया गया है, ठीक है? It says which of the following. That means there are situations which best captures the function of it, as described in the portal. Now it says a federal disaster response council that drafts national level guidelines and leaves implementation to state agencies. Now, if we go back to the paragraph, it clearly mentions that this council have been, sorry, yeah, the council have been responsible to issue guidelines, recommendation to all these things, advising the plan and the blueprint for the central and the state government. So these are the guidelines. Now they say there is a council that drafts national level guidelines and leaves implementation to the state agencies. Could be the answer, which could be the function. Okay. A railway board that sets tariff and license private train operators. Now it's only accounting to the private train operators. The tariff and the license part may be correct, but it is partially correct. We will not go into, and it's a board which talks about. So this is not the correct answer. Now it says a national forest advisory panel that directly administer local forest via appointed. Now this is not the case. It has left things a plan at the center, state and multiple bodies, they allow it. So MSTC is not going to control everything centrally, rather than it is giving its power. They are just issuing guidelines. They're not the controlling body. That's why they can't directly administer. A state electric board that adjudicates disputes between providers and the consumer. Now, this is not the role of the council. The council is only one who's going to issue guidelines, and this is overpowering everywhere. That's why over here also the correct answer seems to be option A. Chalo. Third question. Gujarat State Maritime Board issued a tariff notification for port charges, which a port concessionaire challenged as violative of MSDC guidelines. Now, MSDC guidelines were different. Gujarat State Board have issued a tariff notification. There is a conflict. The port also failed to appoint a port officer to guide an outgoing vessel, which then collided with the fishing port. Okay. Now they are saying a notification was issued for port charges. The concessionaire have challenged because it is violative, and later on he took up his own port, and there was no officer, and it even outgoing vessel have collided with the boat. So there is some incident which happened where there was no port officer. A complaint was filed citing negligence, non-compliance with the guidelines, and absence of pilot. But he raised that these guidelines are violative. Which of the following is the least justifiable statement based on the Indian Ports Bill? Now, this type of questions meant to be left because the facts are not clearly stated, and intentionally these facts have been created this way, okay? So that you read it initially, then you go to the next line and you get confused. But let's see. You say the absence of a pilot or a port officer on board is punishable with a monetary penalty of again 2 lakh. It may be some penalty, but again, absence of pilot, it is negligence, which they have not been following it up. A tariff notification could be the answer, but explicitly mentioning the penalty is not given in the paragraph. The port's deviation from the guidelines cannot by itself invalidate the tariff decision if state law authorizes the board to fix the tariff. Now, this is something in contradiction to what the guideline says. Now, MSDC Council issues guidelines, and those guidelines have to be followed by the board, right? So that's why this is somewhere contradictory, so we can't go with B. The concessionaire can directly appeal to Supreme Court against the tariff decision if it alleges unconstitutionality. Now, what is basically given that there could be penalty, okay, there could be a deviation from the guidelines. We need to identify the less justifiable statement based on the bill. Less justifiable means which is not, whether these options could justify at some given point of time, but these are not the correct options. Okay. So if we say directly appeal to the Supreme Court, could be the answer because it mentioned about the High Court, but tariff decision, if it is because the bill at the center, you can definitely go to the higher authority. But when it says the board's failure to provide a pilot constitutes an imprisonable offense under the bill. Now, if they have not appointed a pilot, imprisonment is a very exaggerated, because on the basis of grading also they mentioned, but we don't know the grade. But this seems to be quite as an exaggerated imprisonment. a very severe one. So this could be the one, because I can definitely appeal, and this is not a going against the judiciary, right? Because this is the process. So that's why I mentioned this question was meant to be left, but because of quite a confusing one. So answer D is the least justifiable statement, because if you have done wrong, you can't be sent to imprisonment. You might be fined, which range to imprisonment. You might go to the court, and deviation will definitely not going to invalidate anything. So all three other options could be justified at some given point of time, but this is the least one. Let's go to question number 4. Now you see how the lengthy ones, the first and the third, were quite lengthy facts as compared to the second and the fourth. Okay. So you have to just read and properly understand and comprehend it. Okay. Got it? Fair enough? Perfect. Now, the Indian Port Bill 2025 mandates that all ports must report an incident involving a threat of pollution to whom? In a manner prescribed by whom? So if it says committee, so committee is only related to at a state level. But this is something which can happen at any level, center or the state level. So this is very limited option. Now, Union Minister for Ports is not the one, rather than he's heading the council. So isliye this is wrong. It could be central state government, the central government prescribed by the central government, because the provisions definitely is being prescribed by the center only, because that is where the bill has been introduced. So to have an understanding which is given in the last part of the paragraph as well, right? At the center and the state level, this somewhere remains. It says threat pollution to the High Court. Now that is where the appeal could be made. So that's why D can't be the answer. We'll go with only option C. Okay. So let's take up the last one. It says in 2026, the Tamil Nadu Maritime Board granted a license to a private operator. Okay. Okay, perfect. Okay. So, Ameya, you are talking about that what you have not got it. Which particular question you are having a doubt? Can you just mention the question? Okay. So let's do one thing. I'll take up the entire explanation till the last question also, and then we can take up the doubts. Will that suffice your need? Right? Because we have to finish this up soon. Okay. Chalo. Okay, so it says the Tamil Nadu Maritime Board granted a license to a private operator to handle cargo at a minor port. 6 months later, the same operator was fined for failing to deliver vessel-generated waste to reception facility. Operator have contested the fine, arguing that the waste was minimal and already incinerated on the boat. Further investigation revealed that the board has not yet submitted a port waste handling plan as mandated under the bill. Now, the bill it was already mentioned that the board has to submit it. Okay. Which of the following statement is incorrect in this context? Okay. Now, incorrect means we need to identify that what are the correct ones. So, private operator is still under obligation to deliver all vessels before the departure. Definitely, he has to submit the report. So, this is wrong because this is correct. The absence of a waste handling plan by the board does not exempt the operator from their obligation under the bill. Definitely, this is true. So this is also wrong because it does not exempt them from working. Okay. They do have an obligation, but it does not completely put up an end. The failure to deliver waste does not attract criminal punishment, but lead to a fine. So this is also true because it will not going to take up to behind the bars, but fine could be there. This is right. We are only left with option B. The operator cannot be penalized since port compliance is a precondition to the operator. Now, port compliance can be, it's a precondition, but he can be penalized, right? So that's why the answer D is the one. Okay. Now, Ameya come up with the third question. As I mentioned that this is a quite tricky one. You should have left this particular question to solve it, intentionally creating a confusing question, not giving all the facts directly. Got it? Got it, Ameya? So basically, over there were two things which are mentioned. One, they have not appointed a pilot, and a port officer, not a pilot, a port officer. That is where they have done a negligence. And also, the concessionaire is also challenging that it is violating the guidelines. Who? The board. That means he is not ready to follow what the board guidelines are there, which is also wrong. So complaint was filed citing negligence, officer appointee kiya, non-compliance with the guidelines, and absence of the pilot. Okay. Now it says which of the following is the least justifiable statement based on the ports. Who will going to justify this? It's the concessionaire. Now, the board's failure to provide a pilot constitutes an impressionable offense is the least one. You can't make the person liable for the criminal thing, because this is not a criminal thing. It's a negligence. It might be considered to be a civil wrong, not a criminal wrong. So why to send a particular person? Because it is not even impacting anyone at a greater level, not impacting anyone's life or threat, right? Threat to life, right? So that's why D seems to be the better one. Okay, so let's go to the next paragraph. Okay, chalo, everyone, come on, come to the next paragraph. Now, as I mentioned about that, it was related with the due diligence of the Prevention of Money Laundering Act. So it says in Shyam Radhakrishna Malpani and State of Maharashtra, the Bombay High Court clarified that the scope of Section 3 of Prevention of Money Laundering Act. Okay. They clarified the scope, what happens in Section 3. Okay. The court held that a mere absence of a due diligence by a professional without concrete. Now, there is an absence of a due diligence without a concrete proof of active knowledge or involvement in money laundering is insufficient to establish criminal liability under the Act. This is what they are talking about. That absence of due diligence without, so due diligence भी नहीं हुआ. Due diligence का मतलब क्या है? A proper check. Not a proper check was not done, and no concrete proof. Now, proof of what? Knowledge and involvement in the case. Either of the cases absence, it is insufficient. The Malpani chartered accountant from companies linked to political leader Chhagan Bhujpal was accused by the ED of helping camouflage illicit transactions tied to the Maharashtra Southern scam. That means the ED came up to the thing, have accused CA, which was linked to some political leader. The ED alleged both acts of omission and commission. Omission means he have hidden certain facts, and commission means he has intentionally done something wrong, claiming that he aided the concealment of proceeds of crime as an auditor from 12 to 15. That as an auditor of the company, who was taking part in the accounting part of some companies, which was linked to a political leader, he was doing something wrong. However, High Court found out that Malpani was neither named or charge sheeted in any predicate offense. That means neither his name came, no charge sheet, no case was filed against him, an essential element for initiating prosecution under prevention of money laundering. If the ED wanted to conduct that particular investigation under the Prevention of Money Laundering Act, because Prevention of Money Laundering Act will going to make a person behind bars. That is what ED, the allegation of ED was not right, because the High Court have made it a point. It stressed that Section 3 requires either a direct role in projecting using proceeds of the crime or an active participation in the laundering process. पैसे की हेराफेरी. Okay. The court emphasized that knowledge must be more than inferential. It must be reasonably attributable. That means knowledge should be, because if you say that you have a knowledge of that particular crime, it can't be proven until and unless there is something concrete. Okay. Or should have a prima facie, something concrete, a prima facie evidence. It held that the absence of material showing his knowledge. If you say that, sir, I do have a knowledge of that particular thing, you just have to prove it with an evidence that you actually have a knowledge, right? If you say, sir, I do have a knowledge how to read Chinese language, I'll give it to you, read it. That is where the concrete proof. His non-beneficiary status and lack of proximity to the initial acquisition of criminal means no nexus was established. No direct link was there. Importantly, the amount attributed to Malpani was explicitly recorded as nil. And he has ceased association with the entities before key laundering events. Okay. Now, the judgment reaffirmed that while professionals must act responsibly, because he was one of the chartered accountant, a professional, the threshold for criminal liability under this is not lowered by professional negligence alone. That means that whatever the criminal liability under the Prevention of Money Laundering Act has been provided, it will not be considered ki, okay, you were negligent, it will going to be lowered down. No. So that is why it says professionals should act responsibly. Now, at given point of time, you will be a lawyer, an advocate. So you should also act responsibly. You can't say, ki, okay, since it was a negligence from my end, I can't be held responsible. No, it won't be lowered up. Your liability will not going to be lowered up. Okay. Now, as I mentioned, since we have read the entire paragraph, we should have directly jumped onto the source. The source says that a news litigation, absence of due diligence, not money laundering. This is what have been provided as a source. This gives us a basic understanding of it. So in the exam also, you can directly go to the source and then read about the paragraph. Sorry, let's go to the question. Devika, senior consultant, audited the financial of several firms by a politically exposed person, Mr. Y. The ED later traced illegal minimal proceeds laundering that these firms between these years. Devika had audited from 12 to 15 in 2023. She is accused under Section 3 for aiding money laundering through omission, like failing to flag certain offshore accounts. She was never named in the predicate FIRs. So, since it was not there, we can definitely say that she will not going to be prosecuted. The question is which of the following most accurately apply that Malpani principle to Devika's case? Since there was no predicate FIRs, even those things happened between 2010 to 4, and she was there from 12 to 15 also, she has not been done. And even if the allegations were there, they were never named in the predicate FIRs. Okay. So definitely it could be that she cannot be prosecuted without evidence of her knowledge or active participation in projecting illicit funds could be the one. She can be prosecuted is wrong. She's liable. All other options are wrong. We'll go only with option B for question 6. Let's go to question number 7. Which of the following statement is correct? We need to identify the correct statement. It says under Malpani case or under Malpani, the threshold for knowledge under prevention for money laundering is inferential and can be established by circumstantial omission. The answer is wrong. Because if you say knowledge is not inferential, it has to have a concrete prima facie evidence. This is wrong. The court ruled that even non-beneficiaries may be held liable under PML if they fail to perform due diligence. This is also wrong because he was a chartered accountant. Even if he was not a non-beneficiary, he will not going to be held liable. Okay. So they say will be held liable is wrong, and also not under prevention of money laundering will also. Okay. Then it says absence of predicate offense against the accused weighs significantly in deciding whether to sustain prosecution is right. Because in the paragraph also they mention koi predicate FIRs, charge sheets were not there. So their absence is definitely going to be held liable. Will not going to be making that person liable. A professional who audits a company after proceeds of crime are generated is presumed to know the illicit origins under. Now they are talking about a professional auditing after the proceeds of crime. Now he didn't even have any knowledge about it. If he's doing the audit and come to know about it, but since it was already done a crime, he will definitely not going to. This is related with the retrospective loss, right? It's also wrong. The answer seems to be only C, which is the correct one. Now select the closest analogy to the court's reasoning in the Malpani case. That is, which resembles the Malpani case. That is what the analogy is talking about, which go similar to what it was. It says, a surgeon cannot be held guilty of murder if a patient dies due to an undetected internal condition that surgeon has no reason to suspect. Now, the fact clearly mentioned that he will definitely not going to be held liable because he was, and over here also it does not say that he has not exercised due care. It says due to an undetected internal condition. So it's like someone who's stressed, but the surgeon does not know about the stress part. But the person dies of a maybe like a kidney failure, but the failure happened because of the stress. So A could be the answer. A journalist publishing leaked document is criminally liable. So already it was a leaked document and publishing if the documents are later found to be part of an illegal espionage. So it's a responsibility of the journalist to be exercised to exercise due diligence. That is what the last part been given. The professional should not consider okay, it was a negligence. No, you should have exercised a due diligence. So this is not closer to Malpani case. A banker is liable under money laundering laws even if they processed a transaction without investigating the account history. This is also wrong. That's a basic responsibility of a banker to do a KYC of all the customers. So this is also wrong because this is not in line. Because this is a sheer negligence. Okay. A lawyer drafting a contract for a client is liable under anti-terror laws if the client is later found out to be fund terror regardless of the lawyer's knowledge. Now this is regardless of the lawyer's knowledge cannot be substituted with the facts that you are catering to a client and you don't about that know about that client. So these all points talks about the last part of the paragraph which mentioned that the professionals clearly mentioned that the judgment reaffirmed that while professional lack responsibility, the threshold is not lowered by their negligence alone. Okay, so they will going to be held liable. So answer A is only which is having the closest analogy. Perfect. Okay, chalo. Last two questions left, guys. Raghav, compliance officer of a mid-sized investment firm, reviewed internal approvals for 5 infrastructure projects financed by etc. 3 years later, those clients are linked to the bribe-generated proceeds of crime. The ED charges Raghav under Section 3 of Prevention of Money Laundering, failing to investigate or report irregular fund movements despite obvious red flags and signing quarterly reports. So, report irregular movements despite obvious red flags. Okay, so they have charged Raghav with this matter. Okay. Now, Raghav argued that he had no knowledge of the predicate offenses and that risk omissions are not intentional as the risk team had cleared them. Now, this is a very strong point. He's arguing that he didn't have a knowledge. That is a right fact, because if he doesn't have any knowledge and they don't even have an evidence about it, because ED is charging this for failing to investigate or report irregular fund movements, but he didn't even have a knowledge about this offenses, right? The ED counters that he was the senior most signatory and thus inherently liable under the. Now, just being a signatory does not make a professional liable. This is what was given in the Malpani case. So if you were to decide the case applying Malpani's case or the verdict, what would be the most justifiable conclusion? So definitely we will say that since he mentioned that he does not have any knowledge, the risk coefficients were not intentional, it was not deliberately negligent, and the risk team has also cleared them. That means he will definitely going to rely on what the team has done. So it will going to be there. He cannot be held liable. So he's criminally liable is wrong. He is liable is wrong. Exempt because responsibility lies with the risk team, not him individually. Factually, this is right. But let's see the B1. Under section as evidence of deliberate concealment of the knowledge is absent. This is an important part because they don't have a prima facie. So D is factually correct, not by the law, but B is actually correct by the law. Okay. So for 9, the answer is B. Let's go to the 10th one. Last question. Priya, senior tax consultant, handled financial restructuring for a group of shell companies. Later found out that the laundering drug cartel money. Okay. Though the predicate offense, drug trafficking FIRs named only the promoters, the ED alleged that Priya facilitated the layering of illicit proceeds through strategic accounting techniques and offshore funding. They say कि directors तो liable है, इन्होंने कुछ ना कुछ, she would have parked money that way that she would definitely be held liable because strategically she has been involved. The ED pointed out that the Priya's own report showed sudden unjustified capital surpluses. Priya's defense is that she acted based on the documents provided by the client and was never aware of the predicate offense. She was not aware, no knowledge. Further, she ceased all professional engagement a year before the ED investigation began. That means she has stopped the professional engagement as well. She neither received a bonus nor held any shares in the firm involved. The ED maintained that her silence despite anomalies makes her complicit by omission. Now the ED is again and again saying that she has omitted things, she will be held liable, but she's saying I didn't even knew about what is going on. It was on the documents which were provided by the client, and that is what I'm working for the client. Now, applying the Malpani standard, what is the most appropriate conclusion? So again, we need to first establish whether there is a direct nexus to the liability or not. And over here, we can say that there is no direct nexus which is being involved because she was not knowing about it. Okay. She was only handling the financial restructuring of the group of shell companies. That's it. Okay. And even though about this drug cartel money, which was laundered by the company, she was not aware. But the ED has put up the allegation. This was the allegation which the ED has posed. It was not the real fact. Okay. Now, Priya's own report shows sudden and unjustified capital surpluses could be the factor which might raise concern, but her defense was she did whatever was based on the documents provided by the client. But definitely, she will not going to be prosecuted. Now it says Priya is presumed guilty. She's non-beneficiary status and lack to the predicate offense insulate her from it. This could be the one. Okay. D could be the one, but not the C and the A1 because this talks about the guilty and the liability part. She cannot be prosecuted unless a direct link, her conduct and predicate offense is proved, or non-beneficiary status and lack of proximity. So lack of proximity is right, but non-beneficiary status is not the answer. So we will restrict ourselves with only option B. D is confusingly correct, but right answer is option B. Okay. Now this brings us to the end of this session, guys. And thank you so much for being part of this session. For all the live viewers, if someone is watching this session later on, you can drop into the comments if you want to have any discussion about any of the question, any of the options, any paragraphical representation needs to be done. So please let us know in the comments. And don't forget to hit the like button and subscribe to our channel. And please share this with your friends who are preparing for it, so that they get at least an add-on material and certain suggestion. Okay, so the key takeaways was how to approach: just read and try to solve the question. If you are able to do it, okay. If you are not able to do it, please don't worry, you will be able to do it. Okay, why? Because you have to read it, you don't have to just think. And the last thing is, please read that last line of the paragraphs as well, and the questions. Okay, thank you so much, guys. Bye bye. Siddhant sir signing off, and we'll soon gonna meet. Okay, bye bye, take care, guys. Thank you.